Danielle Free. Miss Free, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Okay. On November 6, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it speeding 55 miles per hour in a 40-mile-per-hour zone in the 7800 block of Spencer Highway. Upon contact with the defendant, the officer detected an odor of an alcoholic beverage on the defendant's breath, and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4. The defendant admitted to drinking and to taking prescription muscle relaxers on occasion. The officer located a case of twisted teas in the defendant's motor vehicle with 2 open cans of twisted teas, 1 in each cup holder. And
So consuming while driving?
There were 2 open cans in the cup holders, yes, Your Honor. And DICs were read and the defendant consented to blood.
Ms. Free, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you not to drive. Do you understand? You are not allowed to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I'm also ordering you not to consume alcohol or illegal drugs. You will be randomly tested if you consume.
Twisted teas in both cup holders. That's not just drinking and driving. That's product placement for probation. And mixing that with prescription meds. She's driving straight into a courtroom and possibly out of a nursing career.
Consume alcohol, illegal drugs, unprescribed controlled medication. Likewise, you will go to jail. No more PR bonds. Do you understand? Any prior DWIs, Alex?
No, Your Honor.
Any prior criminal history at all?
She has a prior racing on a highway that was dismissed earlier this year.
What do you do for a living, Ms. Free?
All right, guys. Today we're stepping into a heated custody battle where a mother fights for full rights over her child while the father, legally blind, doesn't even bother to show up. As court opens, her attorney moves for a default judgment, and the judge signals she's ready to finalize it. This isn't just paperwork. This is a turning point in one family's future.
Why?
I just graduated nursing school, so I was a CNA and caregiver in an independent care facility. But right now I help take care of my great-grandma, so it's just a lot at once.
So how do you support yourself? How do you eat?
I live with my grandparents and I help them take care of her. She can't take care of herself. She has dementia and a mental disorder.
I'll fill out an application for you. I need to know everything about you, how much money you make, what kind of car you drive, any source of income that you have, money in the bank, stocks, bonds, IRAs. I'll have you fill out an application, but I need to know everything about you. Don't just put zeros because I'm going to send it right back to you. Yes. Do you understand? And I'll see whether you qualify. Above all else, do not drive. Do you understand? There's no justification that you can give for getting in a car. Likewise, don't consume alcohol or drugs. If you have a problem, you better address it, because if you don't, I'm going to do it for you. Promise you're not going to like the way that I do it. You understand? Okay. Do you mind giving me an application, please? Morning, Mr. Singleton.
Good morning, sir. How are you?
Doing great. You know, it's Thursday, Friday Eve. Ready for the weekend, you know?
Yes, sir.
So
see, you have the decorations.
Thanks. Well, it's all them.
Yes, sir.
Your lawyer has asked for me, or is asking for a bond reduction in your case, but you know, my concern, and I guess my very, very primary concern, is public safety. You've got a lot of serious charges, and from what I see, your bond is now at around $200,000. You've got 2 open aggravated assault cases, and you got an assault of a family member with us.
2 aggravated assaults, 1 family assault, and he wants a PR bond. That's like asking for VIP treatment at a crime scene. At this point, even the judge is questioning his own generosity.
Bond is set at $5,002. What did you guys want?
Possibly looking for a PR bond due to the fact that his other 2 cases are extremely high. We believe that he should be able to bond out on that. We have been talks he has been in talks with some family members regarding possibly coming up with money for the other two bonds, but reducing it here would possibly help him out regarding the overall amount that he will have to come up with.
Well, so my concern is it looks like in September, he had an
The courtroom grows tense as the father's disability is laid out. He's legally blind. The mother's attorney emphasizes that only supervised visitation should be allowed, and the judge agrees. This revelation raises concerns about safety and responsibility, casting serious doubt on the father's ability to parent. It's a sharp twist that instantly changes the courtroom's tone.
aggravated assault with a deadly weapon dismissed, right?
I believe that case got filed twice, and they.
So what's going on with the cases upstairs? And is it the same complaining witness as our case?
There's two complaining witnesses on those cases, Judge, and it looks as though it's a different complainant with us.
Is there a weapon involved? Is it a shooting?
On the aggravated assault with deadly weapon, Judge, so in the felony cases, there's two weapons involved, a machete and a gun, a 9mm handgun.
Does he shoot at them? Does he shoot?
At them. So the state would be opposed to lowering bond, Judge, given the severity and the propensity to violence that felony cases also show.
Oh, I think I remember this case. It's about a neighbor, and it's either about like a fence or it's about some bushes or some, right?
So the state's concern is community safety, Judge. So for those reasons, we would be opposed to lowering his bond.
Even if it's not going totally to a PR, if it's possible to do 2,500, that would great.
I don't know, I mean, we gave you a PR bond in this case. I let you out, right? And then you go out, you allegedly have these now two aggravated assault cases where in one, you point a gun at someone.
Shoot them in the head.
And if I remember, it's something so trivial over. Don't talk about the cases though, because I don't want you to.
I wouldn't incriminate myself or anything, but I live by truth, sir. And these people stole stuff from me.
No.
But Mr. Singleton,
Not that.
but there's a certain way when someone takes something from you, there's a certain way that you got to act.
I'm the one that
No.
called the police, Your Honor.
And that may be so, but there's still a certain way to act, right? And if you.
Washington?
Here's where the history gets exposed. The attorney outlines a painful timeline. The father hasn't been present for years and hasn't paid a cent in child support. Meanwhile, the mother had to flee her home for safety. This is more than absentee parenting, it's abandonment. The courtroom begins to see that this case isn't about shared parenting, it's about protection.
Refresh my memory because I just don't remember it.
I can read.
Yeah, go for it. Just a brief synopsis.
On or about September 7th, 2024, complainant Sarver was in his truck when he was awoken by the defendant knocking on the window with a 9mm handgun. The defendant then pointed the gun at complainant Sarver and demanded that the complainant get out of the car. When complainant Sarver got out of the car, the defendant stated that he would shoot the complainant in the head. Complainant Sarver advised that prior to coming home from work and having his incident with the defendant, the complainant too was also involved in an altercation with the defendant earlier in the night. The second complainant stated that an altercation arose between him and the defendant, which resulted in the defendant punching the second complainant in the face, causing him pain. The second complainant punched the defendant back and the defendant ran to his house. Shortly after, the defendant returned with a machete in one hand and a stick in the other and was calling out for the second complainant to come out to the street. So it seems as though he pointed a gun at complainant 1, and then in complainant 2, he punched him, and then when the complainant punched him back, he came back with a machete and a stick.
Sorry, Mr. Singleton, just too dangerous for me, man. I can't give you a PR bond. I already gave you a PR bond. We let you out and then you pick up these two serious cases. You know, if we give you a PR bond now, if we were to lower, I mean, what's going to happen? You're going to pick up a fourth case? We're trying to prevent that from happening, you know?
Order
in the court.
May I speak?
But not about the cases, okay? Just because I don't want you to hurt yourself, you know?
I understand, Your Honor, but I don't recall you ever giving me a PR bond, sir.
We gave you a PR bond on, in our case, we gave it to you on 8/12 of 24. I gave you a PR bond. We let you out of jail. You know, you had certain conditions that you're supposed to follow. No weapons, no contact with the complaining witnesses. And so here we are with two very serious cases. If you're able to bond out and if you have someone, come back, talk, perhaps we can,
My fiance,
no, but
the person who this is.
you're your own worst enemy, Mr. Singleton, really. I mean,
I'm
you're your
sorry.
own worst enemy.
I guess it's the military.
Well, don't blame it on the military. They're choices, right? And
Yes.
sometimes choices are made such that
I know I need help, Your Honor. I'm not saying I.
The judge takes firm action. Full custody is awarded to the mother, while the father, though technically a joint conservator, is stripped of key rights. This moment isn't just procedural, it's decisive. The courtroom shifts from uncertainty to clarity, and the mother finally gains legal protection for her child after what sounds like years of instability and fear.
Don't need help. However,
the problem is that you can't do that after the fact.
I understand.
You got to recognize it before the fact, before it balloons out of control. That's why, you know, and it's not our first rodeo here with you. You've had prior assaultive cases like this. So you have to understand that when you get these feelings, these urges that you're going to lose, you got to try to take care of this beforehand. Now, why don't we have him TRAS'd? Okay, let's see what it says. Let's see how to go forward. You know, if they say that there's treatment that's, you know, I have options available to help you with these issues. And I'm willing to help you and I want to. Yeah, we will do it. But the first things first is I got to have you evaluated to see how we go forward. And if you let me do this, and if you're honest with me, Mr. Singleton, let's try to work something.
I will be.
All right. Can you set up a TRAS for Mr. Singleton? Yeah, please. I'm going to set you for an evaluation. I'm going to have you speak to clinicians. Be honest.
I will.
We'll come back in a couple days. Today's what, Thursday? Come back on Tuesday. Let's talk about how we go forward. Okay?
Yeah.
Look, this isn't the be all end all, but let's see how we go forward. You know, that's why God put eyes in the front. So we go forward. We don't go backwards. All
Yes,
right?
Your Honor.
Okay. All right.
Thank you. Appreciate it.
Stay. Okay. You know, Alan, you know, depending on what that TRAS says, it may also help with what upstairs to try to work out some kind of treatment program so that, you know, because it's all just anger, right? Yeah.
That's the first time I seen her actually. Like that, so it makes
It may be worth exploring because it'll help, you know, hopefully upstairs as well. Yeah, thanks. Yes. Mr. He? Sir. Good morning, Mr. He. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Okay.
On November 11th, 2024, officers conducted a traffic stop for a defective license plate lamp in Harris County, Texas. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed a strong odor of an alcoholic beverage, watery bloodshot eyes, and disorientation. Standard field sobriety tests were administered. HGN 4 out of 6. Walk and turn and one leg stand were not administered due to the defendant becoming belligerent. Walk and turn, prior to termination, they had detected 1 of 8 clues. The defendant read the DIC and refused to provide a specimen. A blood search warrant was obtained and executed.
Any priority to be honest?
No, Your Honor.
Okay. Mr. He, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. We will randomly test you. If we find that you consume alcohol or drugs, you will go to jail. And that's it. You understand? Do you have a valid Texas?
Now the judge moves to lock things down. She declares that the father will only be allowed to visit under supervision. No private contact, no chance for mistakes. This part is crucial. The court isn't just reacting, it's preventing future harm. The mother's concerns are validated, and the safety net around the child is officially reinforced by law.
Driver license? Do you have valid liability insurance in your name? You may continue to drive as long as you have both, and Mr. Murphy will tell you if it does become suspended. If it becomes suspended, you may not drive. Now, because you have a lawyer, we will waive your appearance. You do not need to waste your time coming to court, but you must stay in touch with Mr. Murphy, and he will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're gone and you're not responding, I will issue a warrant for your arrest.
That won't be an issue, guys.
I don't think it will, but we have to put you on notice of what we expect and what, what happens when you start acting up. So we will have you just sign a reset with Victoria. We'll have you get with Fleischer for your bond conditions, and then you guys are free to go. Okay?
Judge, thank you very much.
Guys, we're talking about Akin Pelu. Is he on the docket today or no?
No, you just want us to come back.
Let me give you a cause number, guys. And
I remember this case, Judge.
I'm at a loss of everything, you're on 2 different felony probations, both of those for driving while intoxicated. Both of those are felonies. So it's not only do you pick up 1 DWI third, but you pick up a second DWI third. Get on probation for both of those. And now you've picked up here, driving on a suspended license. We ordered you, number 1, not to drive, and number 2, not to consume alcohol. That's all I've ordered you to do. Just don't consume alcohol and don't drive. Has anything happened upstairs?
Well, Your Honor, to be fair, I think the integrity of the machines are in question. 11/7. So when he picked up the first one on 10/29, you told him to test Monday and Thursday.
You picked up what? The machine?
No, when he when you thought it was a tamper on 10/29, he started testing Monday and Thursday, which in this case helps us. So on Thursday, 11/7, he was here in court where he tested. He tested at 12 o'clock. At 11 a.m., they got a tamper and a sign of alcohol. However, he tested clean with the test you told him to take that day. So which tells me that there.
With custody settled, the judge turns to long-term peace. She warns both sides, no bad-mouthing, no chaos, and no dragging the child into adult issues. It's a reminder that even after the ruling, parents have a duty to protect their child's mental and emotional well-being. This is the judge stepping in not just as an official, but as a protector of peace.
Machine's integrity is not correct. So if the integrity of, and he's maintained that he has not been drinking either time. Every time we did the court, I promise he's not drinking. So if that machine is saying tampering alcohol and he goes and tests on 11/7 at 12 p.m., an hour after the tampering in alcohol, then he may be telling the truth. And I understand what we're dealing with, but he has tampering, sign of alcohol, and then it dissipates and there's nothing there. So
I'm on the same page as you as far as I never want to punish someone who's never done or who has not done anything wrong. That's not, we don't do that. We're the exact opposite. I mean, I scrutinize every single thing that Michael does, every case, every probable cause, I don't think I scrutinize the hell out of it. But at the same time, I also do that with people that are in front of us as well as people with charges, right?
And Your Honor, and to say off the record, I know that you do that. I know that you are a judge that will be very fair in these situations. So I'm just saying that.
So he takes a urine sample. It looks like On 11, what day was it?
11/7.
11/7.
I think the sample was taken around noon. He did two that day, one upstairs and one downstairs. So 11 and 1 o'clock, he had to do two different samples. 11, I think 07, they say he tampers and a sign of alcohol occurs. So he was here in court, but still have two urine analysis around the same time as that he.
Alicia,
Yes,
do you
Judge?
have a test for 11/7? Because I don't have it.
Yeah, so it's probably not in those records because right now it's just presumptive. It was presumptive, but it's negative. So nothing came back. I have it on my end here. It should be.
What time was the positive for alcohol on 11/7?
For the scram report? Let me see.
I thought it was like 11 a.m.
Sorry, normally I don't look over those reports because I don't know how to use them, but I will try to figure it out.
And Judge, I might have an unupdated report. The only BVR I have here is for a scram violation from October 30th.
Yes.
Was there another violation?
Yeah.
Okay.
So there's a violation technically pending on our end because he was coming in that day, so I addressed the violation. And so they were waiting to file it to see if judge wanted that to be filed because he was going to address it at court. And that's what we're discussing from 11/7. So that violation is pending a DVR because judge is taking action on it already.
Do we have a?
I can
The court slams the door on any back-channel communication. The father is barred from directly contacting the child. Everything must go through the mother, and the judge makes it crystal clear. This isn't a punishment, it's control, and it's needed. The message is loud and firm. Access must be earned, not assumed, especially when a child's security is on the line.
I could have sworn you said that there's another presumptive alcohol
On 11/7.
on 11/7.
No, there's a presumptive negative for the POC test that he took, our rapid test.
No, yeah, right.
On
I know that
11/7,
one.
it was a alcohol detected, but.
What time was that?
confirmed. I'm trying to read the report.
Because
but I
that's,
can't remember how to read
see,
the
we've
report.
got a
So I
presumptive.
got it right here for Brittany Gordon. The defendant order was to obtain a scram device. The defendant's scram device has confirmed one tamper event. The tamper event occurred at 11/7 at 12:42 p.m. Now he was taking the test at 12:30
Hold
p.m.
on. Saying it was 11/7.
At 12:42 p.m. Got this email on November 11th. It went to everybody in the court. And alcohol was detected during the tamper. However, alcohol cannot be confirmed as consumption because of the nature of the tamper.
Began at 2:25 p.m. and returned to baseline at 8:04 p.m.
So let's get this straight. He tests positive for alcohol at 12:42, then negative at 12:47. Either he's got superhuman detox powers or the scram device is glitching harder than a Windows 98 update.
We also took another test with you guys on 11/7.
Yes, that was at 12:47, I believe. Let me double check.
What? So at 12:42, he tests positive for alcohol, and then at 12:47, he tests negative for alcohol. Am I right?
It was, sorry, let me see real quick. It was Tuesday, October. That's not October 20th. I'm sorry, Judge, respectfully, I have no idea how to read scram results and everything that's in my email, but I can check on the drug test for you.
Well, so the 11/7, we got the email on November 11th, okay? Then if you go to the email she just sent me, it tells you when the lab test was submitted. Hold on. You just sent me this email. In this email from Average Size Individual Screening Report, on 11/7, it says that it was, one of the collection times was at 12:08 PM on 11/7/12/24. He did negative. So that means while he was in court, he would have to drink. But then he took another test after that. I don't know what the other test is at. What I'm saying, Judge, I'm just saying this whole, if we were in trial right now, the whole integrity of these machines would be in question right now, because in the previous test, because the same exact message that we got on 11/7 was the same exact message that we got on 10/29. Scram temper, alcohol cannot be confirmed, same thing. So what I'm saying at this point.
The gavel is ready. The judge finalizes the default ruling since the father failed to appear or defend himself. With no objections, the case is sealed. This moment marks the mother's legal victory and the child's formal protection. Years of neglect and silence from the father are now met with the power of the court's full authority. Case nearly closed.